Welcome back, everybody, to the Legal Weekly Wine, where we touch the week's hottest legal topics. And we continue on quite a roll here. Last week, we touched whether the 14th Amendment, Section 3, under the 14th Amendment, would disqualify Donald Trump from running again in the 2024 election, which is truly blowing up across the country. So today what we're going to do is we're going to revisit the topic based on the lawsuits that, since we talked, have been filed. There have been 3 lawsuits that have been filed asking to disqualify Trump based on Section 3 of the 14th Amendment. We're going to talk about that and what's happening now. We are also, in the second part, going to talk about Mark Meadows. It all seems political, but what's happening is legal. And this week, Mark Meadows testified in front of a federal judge regarding his actions in this alleged conspiracy, and the question surrounding whether it will be bumped and moved to a federal case, whether he will have federal immunity, and what will happen with the testimony that he gave. So that's part 2. And part 3 is Giuliani's defamation suit. What in the world has happened with it? Why was there default? Why is he sanctioned? And why is he supposed to pay attorney's fees? So these are the 3 topics we are going to hit within the next hour. Don't be afraid of the timeline. If you don't like one topic, skip ahead, catch the other topic, go back to a different one. But those are the 3 that we're going to hit. So follow us along as we figure out what is happening legally across the United States in this last week of August of 2023. I'm Virginia Tirani. I am an attorney. I work with the Tirani Law, LLC, because you never need a lawyer till you do. I am also the CEO and owner of The Law Unscripted, which is hosting this podcast. And with us, we have today a Constitution expert. He's an expert in the Constitution, the amending process, constitutional law, the founding fathers, and rewriting the American Constitution. And we have with us Dr. John Weil from Middle Tennessee State University, who is the Dean of the Honors College. Welcome back.
Good to be here.
All right. So we are so lucky to have you during this continuing debate. Of all of the times that we could have had this podcast be talking about these issues, we are lucky to have our own Constitution expert. So last week, we talked about all of the books that you have written, and I'd love for you briefly to touch on at least a couple of the ones that are especially appropriate in this situation. I understand there's the rewriting of the Constitution, there's the essential Supreme Court decisions, and what are some of the others that you have?
Again, probably the companion to the United States Constitution and its amendments. That's one of the more readable books, for a general audience. And it goes, the frustrating thing about it is I usually only publish it every 4 or 5 years. I think it's in its 6th or 7th edition right now. And I'm already wishing that I had you could go back in and revise it section 3 of the 14th Amendment, as well as a lot of the legal developments.
I think we may need to go ahead and do that. We need to contact the publishers and let's get that started.
Maybe so.
So thanks for coming. What we're going to do as the weekly wine, again, don't go away. Join us for the rest of it. We are getting to each topic. But because it's the weekly wine, we are publishing this on Friday for happy hour. Join us for happy hour. Grab a glass of your favorite wine. Sit back and relax as we talk. Hopefully you won't get too upset, but maybe excited about the things that we're saying. And today I am joining with another rosé. Last week we did a rosé, and I think that at the end of the summer, it's a nice, light, crisp way to go. I am doing a Barton and Goustier, a Rose d'Anjou. And this is again, beautiful bottle. It's a rosé. They're always very pretty. It's a delightful taste, very much the end of the summer kind of taste. So cheers to happy hour at the end of this week.
By the way, while you're drinking,
yes, tell me.
I told someone I was on the weekly wine, and Perhaps because they knew me too well, they asked if it was W-I-N-E or W-H-I-N-E.
It is a play on words. And
yes.
we did struggle with which spelling to use when we started to certify our Legal Weekly wine. But really, please interpret it as you wish. And here we go on the wine. So, Dr. Weil, last week we did talk about truly this article. As a brief recap, this article came out by two leading legal professionals, law professors who were legal scholars, conservatives, as I understand, that they have.
Yes, and then they were joined by a conservative judge, Judge Ludig, and a fairly liberal Harvard professor, Lawrence Tribe.
Right.
So it's not simply a liberal conservative issue here.
Right. So parties on both sides, of the spectrum, that they're alleging that Section 3 of the 14th Amendment would disqualify Donald Trump from even being on the ballot and from running for president. Not that he can't be president or be elected as president, but he can't even be on the ballot. So what is, based on your understanding of it and the Constitution, what's the basis of that argument?
Right. That section was adopted, as we discussed last week. Of course, 14th Amendment was adopted in 1868. The amendment was primarily designed to overturn the Dred Scott decision, which had said that African Americans could not be citizens. And it declared that all persons born or naturalized in the United States are citizens thereof. And then it went on to outline certain rights. Well, there are other provisions of the 14th Amendment as well. One was to penalize states that refused to give voting rights to the newly enfranchised African Americans. Another was a provision indicating that the government would pay Union debts, but they would not pay debts for money that had been borrowed by the Confederacy to fight against them.
Sure.
And then there's Section 5, which is frequently invoked, which is the congressional enforcement power. But Section 3 was designed, what was happening was after the states started rejoining or attempting to rejoin the Union, many of the southern states were electing some of the generals and office holders who had at one time, had all taken oaths to uphold the Constitution, and then instead had given their loyalty to the Confederacy. And so the provision stated, and by the way, there is an out, although,
right.
There's a provision that, we'll start with the provision basically says if you've taken an oath to support the Constitution and then you've engaged in insurrection against it, then you can no longer hold public office. Now, the out is unless Congress were to give its approval. The problem
clause
here, right, if Congress said, well, yes, Robert E. Lee fought against the Union, but he was also a noble man, or whatever.
Right.
We think that he's now pledged to support the Union, and we think that he would do that. They could do it, but imagine it's pretty hard for Donald Trump to go to court and say, or go to Congress and say, I admit that I engaged in insurrection against the United States, but I'd now like to be exonerated for it. So I don't think that's much of an option here. But the question, of course, this is, the immediate question is this something that's simply applied one time?
Right.
We know it was designed primarily for a specific situation involving the Confederacy. On the other hand, you can make an argument that, they knew if it happened once, it might happen again. And this is sort of, fair warning to anybody. If you war against the United States, you engage in insurrection, you're no longer going to be eligible for office. The problem, of course, becomes...
And just to jump in here, they didn't put a timeline on the amendment. There's nothing that says the Confederacy. There's nothing that says only the 1860s or 1870s or, there's nothing that specifically mentions the Civil War, nor is there a timeline that says through whatever X date. It's open. So in my mind, the framers of that amendment at least seem to leave it open for eternity or, the continuing existence of the United States.
Yeah, this goes to, there's been a lot of development, one method, and it's only one of many, but one method for constitutional interpretation is original intent.
Right.
And early on, some of the formulations were a little sloppy. People would say, well, we have a private letter here from Thomas Jefferson or James Madison that indicates that, he favored this or that, so that must be the intent. And over time, people said, well, no, obviously, it's not a subjective intent that was never communicated. And sometimes people will go, it's not even necessarily the intent of the authors as it is so much the intent of the ratifiers.
Sure.
And, truthfully, I don't know how many of them thought about the future. I mean, they were dealing with a very concrete situation. So a very narrow view of original intent would say, that's it, that's all. But as you say, often original intent is combined with plain meaning of the language.
Right.
Plain meaning of the language doesn't have a time limit and so might be applicable. Now, who's going to enforce it, and what happens if you have half the states that allow it and half don't? Well, probably what will happen, it'll go to the Supreme Court, and Trump probably thinks that he has a pretty good chance there, although Nixon thought he had a pretty good chance when he argued for executive privilege in U.S. versus Nixon and ended up, losing by an 8-0 vote, including 4 of his own appointees.
So what we have now then is we've had people pick it up, like you're saying. I think this is absolutely headed to the Supreme Court, because now we were anticipating that there would be lawsuits, and now we have them. The day our episode aired last week regarding this issue, that day, last Friday, the first lawsuit dropped regarding whether Trump could be on the ballot. And it was in Florida. You think we ought to charge
him for legal advice, maybe?
That's right. Holy crap.
I'm sure, if it happened after, it must have been because of our broadcast,
He listened to us. He crafted it.
Lawrence Tribe, Ludick, they just weren't sure. But when you and I,
Virginia Tarani and John Vial.
That's right. They said, well, we got to file a lawsuit.
The famous legal team. They have to do something.
Legends in our own mind. Okay.
Very true. So our wonderful ideas and predictions. And this is interesting because we're not necessarily saying which way it's going to go. Right. Because I honestly think it could go either way. So for us, the idea is, well, we're predicting that there will be lawsuits. We're predicting that there will have to be a Supreme Court ruling on it, or at least go up to the Supreme Court and see, are they going to accept it? But those lawsuits have started now. So we had our first one in Florida on Friday, and go ahead.
Well, the court may very well decide it's moot unless and until he's actually nominated by the Republican Party. But the problem, of course, with that is, after he's nominated, then it makes it much more difficult for that party, if he were to be prohibited from, nominating someone, recognizing, well, he's not going to be the top candidate, so we need to go with somebody else. So I don't know. I mean, usually judicial, those who favor judicial restraint say, if at all possible, keep out of political matters like this, leave them to the determination of the other branches.
Mm-hmm. But what's happening, I think, is they're trying to push the issue before the nomination. So Florida's got one, New Hampshire's got one, and Michigan has one. And each of them, all 3 of them, have chosen this discussion, this 14th Amendment, Section 3 of the 14th Amendment, to move to prevent the secretaries of state for putting him on the ballot. So they are saying, Mr. Judge in federal court, we believe that the 14th Amendment, or misjudge, judge of the federal court. There we go. Judge of the federal court. Mr. Trump is not allowed to be on the ballot. He's disqualified because we believe he engaged in insurrection and rebellion, and these 3 really focus on the second part of it. that they believe he gave
Aid and
comfort to those who were doing insurrection or rebellion. So their
Right.
lawsuits really focus on the second half
Right.
of that. They're not hitting so much that he was doing insurrection or rebellion, but that he's giving aid and comfort. And because of that, we're asking you to prevent and prohibit Mr. Trump from being placed on the ballot, which would mean the judge would have to order the secretaries of state from, to prevent him from being put on the ballot. So they're saying you can't do this.
Something we might add here, and I'm sure you know this, and I did not get the name of the case, but there is one case in which I believe a New Mexico judge has disqualified an individual from office because that person was one of the so-called fake electors.
Correct.
Or was attempted to be. So there's one precedent out there. It's a state precedent. He's not hardly a president. But that could, gives a little bit of aid and comfort to the side that's trying to exclude Trump.
Exactly. So in my mind, I think it's good timing so that we can have a determination before the nomination, not even the election, but before the nomination. Let's find out what the decision is going to be. So that way, if judges start deciding, the other secretaries of state can review the issue and can decide, well, if they're not being, if these other states are not allowed to put him on the ballot, then maybe we shouldn't. And even the Arizona Secretary of State and the New Hampshire Secretary of State, along with his Attorney General, they have come out this week confirming that they are reviewing the issue, that they're actually reviewing this argument, this 14th Amendment argument.
As a political scientist, I need to add something here.
Please.
Which is, it is possible that that a decision for Trump, which might simply be, it's not up for us to decide, it's up for Congress to decide whether an insurrection has occurred, but it's possible that these suits could actually help Trump.
Yes.
Because if the court were to say he can run, he could say it wouldn't be exactly accurate, because not guilty is not necessarily an exoneration, but he could claim it to be an exoneration. I mean, we need to remember we're talking about someone who's apparently raised $7 million, give or take $1 million or $2 million, or $1 billion or $2 million, depending.
Whichever.
Talk to the New York Attorney General, and she might tell you it's a couple billion. But in any event, I think the point's made.
Yeah, and I like that because it could go either way. For me, I just want to see which way. And if we can have a determination before we get to the nomination, we can say, okay, the courts have reviewed it. And they have already pre-decided that he can be and should be on the ballot to be, reviewed by the popular vote, or that he shouldn't. And in my mind, that's important.
We do know, at least in New Hampshire, it's my understanding that the Republican Party has said we're going to fight this. We believe that Trump does deserve to be on the ballot, and you can sort of make it an issue. It's a legal issue, but you can also, if you go to the political science side, you say, well, shouldn't it, instead of the court determining whether he's eligible, shouldn't the American people decide whether he did or did not give aid and comfort? So I don't know if we've talked in this broadcast, but sometimes the court will identify an issue as a political question, which usually means it's one for the elected branches. But here you could sort of broaden it out and say it's really a matter for the electorate decides when. Now, that wouldn't work very well, probably, if you want to original intent. That's not how it worked right after the Civil War. You didn't leave it up to voters to select someone who had previously taken an oath. But I could see the basis of making that as sort of a small d-democratic argument. Let the people decide.
Absolutely, that it's up to them. But the people who put the men who put forth the articles, the original articles, are saying, well, the people should decide, but that's the individual electors. and the individual states, the
Right.
people who put him on the ballot, they're the ones who are supposed to interpret the Constitution. And it's their belief that it should be interpreted in this way, that Mr. Trump did violate this section
Right.
of the 14th Amendment and can't be put on.
As you know, I mostly supervise theses now, but there are times this year when I wish I were actually teaching constitutional law rather than just sitting on the sidelines.
And you did so well, and you taught constitutional law for decades.
Yes, I did. Let's not go into how many.
Okay. I won't give you away. I'll just say decades. 1, 2, 3, whatever.
So did I tell you, I don't know if we were going to get to this or not, but did I tell you about the major mistake that I made this week?
You were mentioning that you did make one. So let's talk about it, because I think it is actually in relation to Trump being on the ballots.
Okay. Yeah, so I was on a call-in program, which I like, by the way. This is going to be your next level of the weekly wine, and we'll see if there's a progression from, when people have had just a sip to the end of the
to the end of the happy hour.
What kind of questions? But I made the statement in very good faith, by the way, that one of the fascinating things about the current Republican contest is that Trump and DeSantis can't both be on the ballot, because I said the Constitution says you can't have two people from the same state as president. Now, practically, what I said probably is true, but it's not actually constitutionally true. And I got home, I said, did I say that? I think I got it right. But I looked it up, and no.
So let's
what the
correct
Constitution says is that if you're an elector, you have to vote for at least one person who is not from your state in terms of president and vice president. So particularly if you're dealing with a state like Florida, I looked it up, they have 27 representatives and 2 U.S. senators, so they have a total of 29 electoral votes.
Okay.
So if you're absolutely convinced that you're going to win the Electoral College by a huge margin and you don't need their votes, you could do it. But it would mean if the election came down to those 29 electors, you could end up with a situation that we had prior to the 12th Amendment, where you ended up with a president from one party and a vice president from the other, because the people who voted for Trump could not vote for DeSantis if he were the vice presidential nominee, or vice versa. Or, could you have a stab in the back? I don't know if that would work or not. But in any event, practically, unless you're from Vermont or, Rhode Island, you have such a small state, is not likely. But even then, 2000, we've had elections that have been determined, 1876, 77 by a single vote or a single state. So anyway, I learned something. I like being on call-ins, because people challenge you and then you think, okay, did they get it right or not? I got that one wrong.
But this is fascinating. So it's a different constitutional argument.
Yes.
And it's not the one to disqualify President Trump, former President Trump, from being on the ballot based on any actions that he did, but it's a separate constitutional issue with regard to state residency.
Right. And apparently in the Bush-Cheney, so I guess it would be 2000, they barely escaped this, because Cheney had been a resident of Texas, but he switched his citizenship. He got a driver's license, and maybe even a residence in Wyoming. And so it did not become an issue, but otherwise it could have become an issue.
So what happens? How do we prevent it from being an issue? Would one of them have to drop out of the race?
You need to win by a big enough margin that one state's votes don't matter, basically. Wow. But, in the current, to take another example, right now you have Tim Scott and Nikki Haley, both hailing from South Carolina. So it's unlikely, although there would be some advantage to a ticket like that, a woman and an African-American or vice versa.
Right.
But probably it wouldn't be prudent to run two people who are both hailing from the same state.
Oh, my goodness. Okay, so there's even more complications, more constitutional implications that I hadn't thought of. Wow.
Well, that's how we learn.
Okay, so now we are going to, for everybody, we're going to do part 2, and I'm turning some volume down here. So part 2, so we're putting the constitutional issue regarding the upcoming election to the side. That was part 1. Part 2, on to Mark Meadows.
Okay.
So Mark Meadows, let's make sure we get everything right. Mark Meadows was the former White House chief of staff for Donald Trump. During the election time. And I want to make sure it's clear to everyone why we're talking about this on a legal podcast. Again, it seems like a political one based on all the players that we're talking about, but we want to make sure that we're talking about the constitutional issues, the legal issues, which are hand in hand, constitutional law. And in this one, it's more practical. The question with Meadows that has come in this week is, what is the role of the White House chief of staff? And how does that affect him on a state indictment, a state criminal indictment, where he has been charged under the Georgia indictment against the 19 defendants related to...
This is Fani Willis, the indictments that she's brought in Georgia.
Exactly. So Mark Meadows is one, as the chief of staff, is one of the 19 defendants named. He's being charged with 2 counts, the racketeering, the RICO count, the racketeering count, as well as the solicitation of violation of oath by public officer. And he has made a motion in federal court. So Fani Willis's indictments are in state court. And he has gone to the federal court and said, this case for me should be removed from the state court into the federal court. And the reason he is suggesting that this happens is this little federal law that says that if you are acting within your federal official duties, then the state case can be removed to federal court, and you may have immunity for your actions that you did as a federal official.
And judges in general typically have immunity. You know, they can make a really lousy decision, and unless they did it on the basis of bribery or, utter corruption, I'm sorry the judge made a mistake, but judges have to make opinions, render decisions all the time. If we held them liable every time we thought one of them was wrong, no one would ever become a judge under those circumstances. So,
exactly.
So the doctrine of federal immunity, president has a certain immunity. He can sometimes fire people that you would think was without cause, but he's head of the executive branch. He has the right, in many cases, to do that. Police officers have immunity.
Yes.
Sometimes, if they're, well, depending on the case, they don't have immunity to beat people up to death and that sort of thing.
Right, but they have a qualified immunity.
Right. You realize that they may have to make decisions on the spur of the moment that are not the best decisions, but they're the decisions they had to make. So, and the doctrine of immunity is not terribly unusual, but and I think what we're going to find here, I think, is we're going to find a mixed bag. I think we're going to find that as chief of staff, part of what Meadows did probably was part of his regular job. But to the extent, one of the examples that has been used is, yes, he's the chief of staff, but if the president were to say, I want you to help me plan to rob a bank, then you could no longer claim that participation in that event was part of his regular job.
Right.
And again, when I said it's a mixed bag, you may find that certain, maybe setting up a phone call, if that's what chiefs of staff do, maybe that in and of itself wasn't culpable. But if he participated in the phone call, or if he called ahead and said, here's what we're going to try to get you to do, or that sort of thing, then he might. And I think what'll be fascinating, there's an article just out on that I just read in which somebody says what you ought to do is judge, what was the term that I gave you? I gave it to you. We talked about it earlier.
Oh, goodness.
I want to say not preponderance of the evidence. No, totality of the circumstances. So it might be, or it may, maybe what the judge will say is, well, I would agree that for in terms of your indictment, this charge looks like it would go in federal court, but this other doesn't seem to be part of your duty, and so you can be judged here. I don't know if that's how it will go out, but I believe there are actually arguments being made Thursday afternoon. Is that right? And then
at least
so
being
might
filed.
even know by the time people are watching this.
Exactly. So everyone watching, we're taping on Thursday. It comes out by Friday for edits and everything. But you're right. They have to have filed, I believe, by the end of Thursday.
Yeah.
As to additional arguments that the judge was looking for, at least into Friday. And I believe that the judge was seeking a specific type of argument where he was suggesting that, or the question is there a difference, or what happens if he's qualified under some actions?
Right.
But not all actions, like you were saying. Maybe, the one phone call doesn't count, but the other one does. So what if all of his actions don't fall under it? Not all of his actions were, federal. They're not all within his specific role as chief of staff. Some are outside. So what happens then? And I think that goes to your question. Would one charge be pulled out and brought to federal court and the remaining charge be left in Fulton County in state court, or would both come with it? So if he's qualified in some but not all, I don't know. And the judge, I appreciate the judge taking his time. It's District Court Judge Steve Jones said that he understands that this may set precedent, and it will be.
And apparently there is no precedent.
None that we know of.
Is what he's saying. So yes, it could be a very consequential. The thing about judicial decisions, they set precedents.
Yes.
And to the extent that the courts go with stare decisis, then you can't just look at how does this affect Meadows, how does it affect Trump, how might it affect a case 50 years down the road or 100 years down the road. Exactly.
And then the other defendants who have started filing the same motions to remove their cases to federal court based on qualified immunity.
Right. And of course, then I think we're going to get to this, but you also have two of the defendants who are asking for an early trial.
Correct. And Sidney Powell and Kenneth Chesebro.
Right. And so the question is, can you try some of them earlier than others? Right. And I think we talked last week, I believe Clark was the first to do this request. And it's either very, very smart or very, very stupid. I mean, it's hard to say.
It could go either way. It could be the best decision any of them made, and he made it first, or it could be the absolute worst. This is such an interesting time because there's so many precedents that will be started because there are so many that this hasn't been addressed before.
And to my knowledge, there's never been, I think there's been RICO cases that have had 6 to 8 individuals, but I'm not sure we've ever had one with, I think it's either 18 or 19 defendants at once. And so I don't know, just the logistics.
And Willis is still wanting to try all 19 at the same time.
Well,
the motion
she's saying she wants to. I don't know if she really does or not.
Right. And that was, some of the motions that were filed this week as well, is she's saying we want clarification from the judge as to whether he meant for all of them to be set on the October 23rd day or whether he meant to actually separate them. Yeah. He's granted that day for at least Kenneth Chesebro and Sidney Powell. But what does that mean for the rest of the defendants? And she's saying, I still want all 19 there. So we're going to see what the judge does with that. But for Mark Meadows, one of the questions that the judge asked was, is there a role under, and this is for you, our Constitution expert, to see if you even know, is there a role under Article 2 of the Constitution for the president in a state election or any election? That is the judge's question that was on record. What do you think?
Well, I mean, certainly one role that any president can play is you always have the right to go to court to challenge you or someone under you to challenge electoral results. if you think there was fraud involved. I mean, there was nothing illegal about Gore challenging Bush or vice versa during the 2000 election. There wasn't anything illegal about Trump forces. Basically, there were like 50 appeals, and they were in multiple states, asked for recounts, asked for clarifications, examination of evidence. Now, unfortunately for Trump, all of them, I think, eventually went against him.
Right.
So you actually have that rule, but I think, constitutionally, there was a pretty clear division between, think about it. The president, particularly if he's an incumbent, should not be deciding who won the election, right?
Right. So under the Constitution, which article is it that discusses the elections, and whose responsibilities and roles are they?
Well, I mean, the easy part is Article 1 is the legislative, Article 2 the executive, Article 3 the judicial branch. And I think much of it, I'd have to take a think about this a little bit, but most of the Electoral College, I believe, is outlined in Article 2. That would make, it's under the executive branch, but there's actually, one of the more problematic things, I think it's absolutely clear that the vice president has a ceremonial role, as president of the Senate. And, the ballots are open. He says ballots of Florida go here, ballots of Georgia go there. But that turns out to have become problematic because apparently for the first time in history, you have a president leaning on his vice president and saying, I either want you to not count a state,
right, or
at the very least say, we have two interpretations. We're going to send it back to the state to decide. And by the way, this is an argument that seems to have been hatched. I don't know if it's Cheeseborough and/or Eastman, or one. I'm not sure which one of them
the attorneys
came up with it. But there has been in California. There's a 92-page analysis that has been done there, in which someone says, okay, Eastman professes to go with original intent. He goes through each election in American history, or pretty much all the ones that are relevant, and he says there has never been a case of a vice president being asked or exercising independent judgment of his own. He's basically a clerk, and that, of course, I think that argument is being made as to whether Eastman should be disbarred from the California bar.
Correct.
But it obviously has, some have said maybe, it's such an unusual thing. You hate to go in and change the Constitution just because, one person tries to arguably misinterpret it. But, I could see somebody saying, well, vice president shouldn't be determining the results. But in case anybody is misunderstands the role of the vice president, his role is a ceremonial role.
We'll write it in.
Or better yet, we're going to appoint, I don't know, the administration of the General Services Administration.
They'll just read it off, right?
Somebody, a judge, someone who you would think to be nonpartisan. Think of it. The amazing thing about what Pence did, although for any precedent, Richard Nixon certified that John Kennedy won the election.
Right.
Albert Gore Jr. certified that George Bush had won. And I suppose Thomas Jefferson had to certify that John Adams had won the first election in their contest because he was vice president. You had a Federalist president and a Democratic Republican vice president, but Jefferson didn't say, well, I'm going to discount this state because I'd really like to be president myself.
Sure.
So,
yeah.
Anyway.
So with Meadows, I think the big question will be in his case two parts is what is his role? Was he acting within a federal role?
Right.
And then what's going to happen with his testimony? Because he actually testified. And let me tell you, as a former prosecutor and a former criminal defense attorney, my jaw hit the ground when I found out that Meadows was testifying, because if I had any defendant on either side, prosecution or defense, who was indicted, facing actual criminal charges in a court, and I found out that they were going to testify under oath on the record in another court about issues pertaining to that indictment, I would have lost my mind. As a prosecutor, I would have grabbed popcorn and joined the cause, turned on my video camera, joined the cause in the back. As a defense attorney, my stomach might have come out of my body, and I may never have eaten again, as sick as I would have felt, of saying, oh my gosh, why are you testifying and putting on record statements that can then be used in the prosecution that is pending? And on top of that testimony, not only can it be presented, if it doesn't go up to federal court, if it doesn't get removed to federal court and stays in the Georgia state court, all of those statements Miss Willis can bring in. She can bring them in her prosecution against Mr. Meadows and say, this is what he said. He's admitting, and I've seen multiple legal scholars
some of his
on
testimony, he did have some, as I would as well, some lapses as I don't remember.
I don't recall.
But there were some other parts where he did seem to say, yes. The attorney general told me that Trump had lost the election. His counsel told me he had lost the election.
So he's admitting that he knew.
Yes, I continued to proceed. I mean, that on the surface seems inculpatory.
It does.
One of the fascinating, we should probably repeat something from last week.
Yes.
Which is, the tricky thing about this is, if Trump were to be reelected, he could probably pardon Meadows. He might be able to pardon himself. That's another question.
If it's a federal case.
Right. He can pardon him for a federal case, although ironically, it appears as though Meadows has cooperated with federal prosecutors. It appears. We don't know for sure, but that's, much of the evidence that they have seems to be based on what Meadows would have told them. And
he was listed as one of the unnamed co-conspirators, but was not indicted.
And what's fascinating is, the special counsel has taken some pride in saying, I have not cooperated with the Georgia prosecutor.
Right.
But this really could work. If Meadows has spilled the beans on the federal case and then is indicted at the state case,
right?
He really could be, he could be a pretty sad case by the end of it.
It could be. It was a calculated risk. A very risky decision, and we're going to see how it plays out. But I am not the only legal expert out there saying that this was a really big risk. And I've seen several say, wow, he just confessed to everything they've alleged against him. So it could be used in evidentiary terms as an admission by a defendant, an admission by a party opponent of this. He admitted to it. He confessed in public, and it can be used. And that brings us, let's talk about John Eastman. There's another attorney who's also given public statements this week. Now, his were on a court record. They weren't under oath, but they were made in a 2-part interview with Fox News in public, recorded by how many people? How many news networks? It's been played over and over. So even though he can say, oh, I wasn't under oath. Oh, so you lied to the American public. His statements can still be used. And from that interview, did you see this?
I'm not sure that I have.
Okay, so his interview was on Tuesday and Wednesday with Fox News with Ingraham. And he is still saying that he believes the election was stolen, that there was fraud in the election. He's saying,
well, and Trump is still saying that.
correct.
As I understand it, yeah.
They are both saying this publicly, and they're saying, Eastman's, one of his quotes from the Fox News interview was, "We did nothing wrong." Then he's saying on public news nationwide that he explicitly told Pence on January 4th that rejecting the electoral votes entirely would be foolish, but he then advocated for him at least to try and sort out the impact of the illegality of the election results and delay the vote.
Okay, I have seen that. Yes, I mean he and Cheeseborough Bose seem to be on record as saying this probably won't hold up in court, but we ought to give it a try. It might work. In fantasy land, in our mind, it's going to work, so why not?
And he is saying, they're trying to indict me for being a zealous advocate for my client as an attorney. And I do get that. I have to say, as an attorney myself, you are supposed to find ways in the law, make a good, solid legal argument, even if it's never been made before.
Sure.
Just like this 14th Amendment issue. Well, okay, no one's raised it before, but it doesn't mean that it's illegitimate. So let's talk about it. So as an attorney representing a client, I would hope I would not be, charged or indicted for some zealously representing my client. But I think the difference here is the allegation by Willis, by Georgia, is that he was not just zealously advocating, but that he was actually, as an attorney and as an individual, advocating for something he knew was untrue.
Basically malpractice.
Misinformation, lies, false claims. And as an officer of the court, as an attorney, you're not supposed to submit false claims or allegations or things that aren't true. You're supposed to argue zealously, but
and
not
even
with things that aren't true.
If you have a client that you believe is going to lie, there
are rules.
You're right. You're supposed to advise them not to, right?
Yes.
And can, in some cases, even withdraw from a case, right?
Correct. You cannot support any, a client in actual criminal behavior or in lying, any kind of perjury. So if you know that they're doing criminal behavior on almost every ethics rules that I can think of throughout the country, if you know that a client is committing criminal behavior, is engaged in criminal behavior, you cannot use your representation to support that criminal behavior. And I think that's why, Eastman is up before the California bar, where they're saying, we're going to take away your license. We're at least going to review taking away your license. And what
are we going to discuss the Giuliani thing too today?
That is coming next. So for Eastman, I think to conclude briefly is his words, even though they weren't under oath, are just as much able to be used against him in any court. Any of those 19 defendants, I would advise is not to talk.
Right. You can't use them against him for perjury, right?
Correct. You can't say perjury.
You can use it to, if you were cross-examining, didn't you say here?
Absolutely.
This? And, so which is it? Do you tell the truth only when you're under oath or never? Or
when you're on Fox News or when you're in the court?
Exactly.
Right. When are you actually telling the truth? And even without cross-examination, they can still present it as his own words to try to prove that he knew what he was doing and that he was part of this racketeering enterprise. So that leads us to yet another defendant. We're going to hit the last defendant today, part 3. So if you don't want to hear about Giuliani, we will see you next week. But if you want to stay tuned for Giuliani, he's got an entirely different issue, but one that will also impact his claims and his charges, where he has a defamation case. And it was just, as I understand it, it was just ruled against him. A ruling was made by the judge against him that said that he is guilty of defamation of the 2 Georgia election officials, the mother and the daughter.
Right.
Of defaming them and telling lies about what they did or did not do with regard to the election results, the election votes and counting. That they have brought a defamation claim for him, and the judge has ruled in their favor. in a default judgment, ruling that he did defame them by telling lies about
and actually,
them.
I believe that this is where it gets really complicated.
Yes.
But it's my understanding that he actually stipulated
Yes.
that he had told lies about them.
Correct.
And when you stipulate something, then that becomes, for a matter of law, that becomes
Truth.
a fact.
Yes.
And why he did that, and I still can't understand. There's some indication that he's having trouble raising money and getting attorneys for himself. I don't know if that came into play here or not. But there's a couple issues here. One is, well, just the most obvious. There's a difference between libel and defamation. Libel is written, defamation is oral. This was primarily, as I understand it, these were oral statements that he made
Correct.
in front of cameras.
Slander.
Yeah. Right. And they deal not with, it's not a claim that he's making against Joe Biden.
Correct.
Who you would assume running for office, being a seasoned politician, would have relatively thick skin.
Correct.
It's against someone who's, in a sense, they're public officials, but they're really low level. I mean, you don't expect a person counting votes to do anything other than count the votes. They don't have discretionary authority to speak of. And so, if this were a public figure, they would have to establish, if he hadn't stipulated, they would have to establish that he made what's called actual malice, that he knew the statements were false, or he made them with reckless disregard to whether they were true or false or not. Because these are relatively private citizens, you have a lower standard of proof here.
Correct.
But then, why don't you explain, since you're the lawyer here, two kinds of damages that might result from this case.
Right. So there's the compensatory and then there's the punitive. And the compensatory is to try to make up for actual damages they incurred. Did they lose their job? Did they lose income? Did they lose potential workability because of these lies that were passed around about them? Did they incur the legal fees potentially, depending on the law? I think
the law. I think that's already been established. My understanding is the judge has already said Giuliani has to pay their fees.
Yes.
Up to this point.
Correct. But that was for another reason.
Right. Am I right? Compensatory damages. Now we're going to get to punity, but compensatory damages could be also for loss of reputation.
Absolutely.
Is that right?
Yes.
Yeah.
It's as if it's pain and suffering. If it were a regular personal injury case, it would be
emotional
pain and suffering.
Distress.
Defamation is a little bit different because it's the impact on your reputation in the community. And they're saying, not only is it in the community, but the entire country has been told these things about us. So now, this isn't even just local. This isn't even my local church and my local community. This is across the nation, that my reputation has been so damaged throughout an entire country that I deserve more compensatory damages.
And it's not a fair fight.
Correct.
It's here's someone, America's mayor, attorney for the president of the United States, who's beating up on poor little me.
Right.
And, frankly, for those who watched the congressional testimony on this, I thought among the people who testified, this mother and daughter were among the more persuasive. I mean, just about anybody, what would you do if the president's, one of his lead attorneys starts making accusations against you that aren't true? It's not, and particularly if you're intimidated, it's not as though you're going to grab a mic and the first person is going to give you an answer. You're not going to be on equal grounds in responding.
Exactly.
So I think they really have they have a strong case if they've already been awarded the lawyers.
But here's the thing: is they've been awarded lawyers' fees for a different reason. In this particular case, and this is where it gets really interesting on a legal basis of not just did they file a case, but the judge has awarded attorneys' fees because of discovery issues. So she had ordered discovery requests. These are questions and answers, questions that one side can pose to another in a lawsuit, and the other side has to answer. They're required. Now, they can make objections, certain objections to,
Right.
well, this is privileged information, you can't have it, or this is irrelevant information. But under most rules, there are certain questions that really have to be answered. You have to produce evidence, you have to produce records, and it's under oath. And in Giuliani's case, apparently these questions were asked and evidence was never produced.
Right.
And the judge ordered it, which is common, where you bring a motion to compel discovery. So the women made a motion to compel him to produce the records they asked for. The judge granted it, saying, Giuliani, you have until this date to get that information, and he didn't meet it.
Right.
So the judge said, well, you violated all of these rules. You haven't produced the evidence. Not only, they could say, well, we're going to do this as in a trial, we're going to say it's presumed that you destroyed it, or we presume that it's against you. But in this case, she said it's done. We're sanctioning you. We're going to sanction you for these violations of discovery. You never produced these records. You never produced, I believe it was a lot of electronic records, emails, and that sort of thing. His attorneys are saying, well, we had to give it to the FBI. The judge is saying that's no excuse. There is the issue of, well, I've been in this dispute regarding attorney's fees and costs, so I can't get the evidence. But she said it doesn't matter. You haven't produced it. The other side has incurred all of these attorney's fees and expenses to try to obtain the information they're rightfully entitled to. So we're going to force you to pay their attorney's fees and costs for all of this time.
But we can't stop, right, before an attorney talks about punitive damages, right?
Yeah. Let's go and get it.
So compensatory is just putting you back to where you would have been.
Right,
now,
making
let's
you
talk
whole.
about punitive damages, right? Every attorney loves to talk about punitive. I'm assuming every.
Oh, absolutely.
Yeah.
Punitive damages are on top of the let's make you whole kind of damages, as if money can make you whole. But it's the only thing we have in the legal system. And as a personal injury attorney, that's what I have to talk to other people about is there isn't anything else we have in our system to make people whole. We only have money. And it's not enough, but it's what we have. So there's that, but then there's punitives, which says, okay, not only do you have to make me whole, but I am fining you for your extra bad behavior. This is going to make an example of you to other people who would engage in such reckless behavior that so substantially harms someone that it was outside of normal negligence.
You know, it's almost as though it should have a different name, because what it really is, it's deterrent damages.
Yes.
I mean, it's punishment in the hope that other people will look at that and say, my gosh, before I start accusing somebody, I better make sure I have my ducks in a row.
I shouldn't do that.
I have this.
Yeah. One of the most common examples of punitive damages and I work in Virginia, Maryland, and DC, and in Virginia, there's for personal injury claims, you get punitive damages if it's a car accident that was caused by drunk driving. And it's very similar. We want to deter people from drinking and driving.
Right.
So it's not just a normal crash. This isn't just negligent, reckless behavior while driving. This is you got behind the wheel while you were drinking. So we're going to punish you. It's punitive, which is a punishment.
I wish I could remember the name of the case, but there was a case we used to have in our case book about someone who basically said they couldn't help that they were an alcoholic. And what the court said is, well, you know, we're not. I think they sort of said we're not sure we can decide that. But even if you can show medically that you have an addiction, to our knowledge, there's no addiction that requires that you drive while you're drunk.
Exactly, that you get in a car. In Maryland, so if you are known to be drunk, if you have multiple drunk driving charges or convictions, then there's a medical board within the Motor Vehicle Administration that can suspend your license for a medical condition. So they're not saying, okay, well, if you are medically addicted, if you have an abuse of alcohol, well, that's fine. But like you're saying, that doesn't mean you should drive.
Right.
So they're not trying to punish the addiction. They're punishing the behavior of choosing to get in a car.
To go to the bottom line, which is where probably more attorneys go than political scientists. But am I right? Punitive damages are often multiples of compensatory damages.
Absolutely. They're usually treble damages.
Right. There's a case that I think actually got lowered in court, but there was a case of the person who purchased, I believe, a Mercedes or really high class car, later discovered that it had $3,000 of repairs on it that he had never been told about. And so they gave him the $3,000 or whatever it was.
Right.
They gave him that plus, $3 million for daring to sell somebody a new car that really wasn't a new car. And again, I think the court lowered. I think they maybe gave him like $50 million.
A lot, right? They reduced it.
You can only have so many multiples before it becomes ridiculous.
Yes,
but the deterrent. This is really it's really an awful thing.
Yes, for
a person in power to, in pursuit, and of course it wasn't his. He was working for a client, but. Right. In pursuit of trying to get somebody elected, to go out and lie about somebody, just sort of pick a name out of the hat and try to blame them. And the fact that they were African-American women, I suggest, probably made them particularly vulnerable, to this, kind of damage to reputation.
Absolutely.
So, if I don't think I can be chosen for a jury in Georgia, so I think I can say if you put me on the case, I would be likely to give fairly high punitive damages because I think it's something that should be stopped.
Right, and the judge has allowed them. So the judge is saying, okay, we're finding in your favor. There is a judgment against Giuliani for defamation, and now there will be a trial on damages only. So how much will the compensatory be? How much will the punitive be? And in the meantime, he's still required to pay the attorney's fees and costs for the litigation thus far based on the discovery issues.
Yeah.
So that's where we are. So that's goodness. We've talked about, I guess, 4 defendants: Trump, Meadows, Eastman, and Giuliani. Who knows what's next? At this point, I don't know what's coming next. Each week will tell, but we hope you've had a good happy hour. This has been a great conversation. Thank you, Dr. Vial, for joining me.
You're welcome.
All right. We'll catch everybody else on next week's Legal Weekly Wine, where we do discuss the week's hottest legal topics. I'm Virginia Tarani with Tarani Law LLC, based in Virginia, Maryland, and DC. We are hosting the Law Unscripted, the Legal Weekly Wine. Lots of titles here with Dr. John Vial, and we will catch you next time.